Welcome to episode 4 of For the Good of the Game, a podcast where we examine the issue of public interest litigation through the lens of one case, the challenge to stop the 1985 All Blacks tour of South Africa. When we finished the last episode, Paddy Finnegan and Phil Recordon had won an important victory. The Court of Appeal, in a decision delivered by Justice Robin Cook, had recognised their standing to bring their case. We examined how the Court of Appeal's decision was different to what was decided in the High Court, and how this reflected the different philosophies of the judges. But really, all that had been decided was that the plaintiffs had standing to bring a claim that the rugby union had acted outside the objects of its constitution. In particular, the object was to promote, foster, and develop the game of rugby in New Zealand. Litigation can sometimes be a frustrating process. Winning a case may require many different hearings in different courts. In Paddy Finnegan and Phil Recordon's case, it meant going back to the High Court in Wellington. This episode looks at that court case, the challenges faced by the lawyers on both sides, and the decision of the court. The High Court's final decision illustrates the fine line between law and politics. When we think about this case, it's useful to bear in mind the following question. Was this a decision that should have been made by a court? Or should it have been left to the rugby union, or perhaps the government? This is a question that goes to the heart of separation of powers and the appropriate role of courts in New Zealand, issues we have looked at throughout this podcast. The Court of Appeal's decision was made on the 21st of June. The trial was set down to begin on the 8th of July, only 2 weeks later. In the world of complex civil litigation, 2 weeks is a very short time to prepare a case. A process that would ordinarily take months was being truncated into a matter of days. This was necessary to ensure that the case could be decided before the All Blacks were scheduled to leave the country on the 17th of July. An important part of bringing a civil case is a phase called discovery. This is where the two sides exchange documents that relate to each of their arguments. In this case, the plaintiffs and their lawyers needed to review the documents that showed how the rugby union reached its decision not to tour. If it was clear from those documents that the Rugby Union Council had not considered its duty to foster, promote and develop the interests of rugby union in New Zealand, then it meant it had a strong case to say that the rugby union had not acted according to its constitution and that the decision was unlawful. Ted Thomas, the senior lawyer for the plaintiffs, explained to me how the discovery took place.
Sean Elias and I were in Wellington and were told by Douglas White, who was acting for the rugby union, that the box of documents would be delivered in due course. And they were actually delivered to us in a restaurant in Wellington. And I can recollect at one stage reading some of the documents that had been discovered, either letters from Seth Blasey, the chairman of the rugby union, or minutes. And I read something and I said, Sean, I think we've got them.
From reading the documents, Ted Thomas believed it was clear that the rugby union had not primarily considered the interests of rugby. Instead, he realised that he could develop an argument that the rugby union had fallen into what he called a siege mentality.
Their main concern was fighting John Minto and all the protest movement. They weren't going to lose. They never once asked about rugby. What will the impact of a tour being on rugby? What will happen in South Africa? How will that affect the people back here, our supporters?
It might be a bit of an exaggeration to say that the rugby union had never once asked about rugby. Certainly, there are references in the Rugby Union Council's minutes to the interests of the game. But it is clear that for at least some of the councillors, they saw the tour in a different context. They saw it as a battle of values, between traditional values, where sporting contacts with South Africa were part of New Zealand's cultural tradition, and anti-tour activists and the Prime Minister, who were a threat to those values and way of life. Ted Thomas was going to make a case that by casting the debate in this way, the rugby union had fallen into the siege mentality and failed in its duty to focus on the interests of rugby in New Zealand. In addition to the documents from Discovery, the lawyers also started putting together a list of witnesses. One star witness would be the activist Reverend Arnold Stofile, a leader of the United Democratic Front and the South African Rugby Union. The South African Rugby Union was a multiracial union, closely linked to the anti-apartheid struggle. It was a rival to the segregated South African Rugby Board, which selected the Springbok team. Reverend Stofile could appear as a witness to describe the segregated nature of South African sport and the oppression of dissenting voices. But he knew that his involvement in the case could come at personal risk to him. Here's Ted Thomas again.
I was remarkably impressed with him, and I asked him if he would mind staying on to be a witness in the hearing that was coming up. And he readily agreed. And he was immensely impressive because as he left my office and stepped into the lift, I said, "You realise that giving evidence in this case is going to cause pretty serious repercussions for you at home?" He says, "Yes." He says, "That's just something that has to happen."
Reverend Stofile knew that by agreeing to be a witness in this case, he was setting himself up as a target for police on his eventual return to South Africa.
It also created problems, of course, as Ted had anticipated, because I had young children, school-going children, and a lot of other things. And so it created a lot of a dangerous situation for myself and my family and so on.
In addition to Arnold Stofile's evidence, the lawyers also summoned a number of sports players and administrators. These included the former All Black Chris Laidlaw, the head of the New Zealand Olympic Committee, Roy Dutton, and the teacher and rugby coach, Murray Deaker. This evidence was intended to support the 5 arguments made in the plaintiff's statement of claim: that the tour would tarnish the image of rugby, that it would discourage people from supporting rugby, that it would discourage sponsorship of rugby, lead to rugby clubs suffering damage to their property, and harm the development of rugby at the club and school level. The lawyers claimed that these 5 arguments showed that the decision was not made in the interests of rugby. The evidence was sharply opposed by the rugby union, who instead argued that the 1981 tour had not caused long-lasting damage to New Zealand rugby. The union was still earning money each year, and John Graham, the principal of Auckland Grammar School, was prepared to tell the court that there were more rugby teams at the school than there had ever been before. All of this evidence was to be put to a judge at trial. The judge was Maurice Casey, an Auckland-based judge who travelled down to Wellington for the hearing. The hearing started on the 8th of July, a Monday. Ted Thomas began his argument by extensively reading from the documents they had obtained in discovery. This included minutes from rugby union meetings, where members of the council had discussed a meeting with David Longy, which we described in the first episode of the series. Those minutes, according to Ted Thomas, showed that what the rugby union was most concerned with was finding a way to beat the Prime Minister, and did not include a thorough consideration of the interests of rugby. By the time Ted Thomas finished, it was already Tuesday afternoon. It was then time to call the plaintiff's first 4 witnesses: Patrick Finnegan, Phil Recordon, Arnold Stofile, and Roy Dutton, the head of the New Zealand Olympic Committee. Patrick Finnegan and Phil Recordon both talked about how much damage they thought that sporting contacts had done for the image of rugby and the everyday experience of rugby club members in New Zealand. Arnold Stofile's evidence was more dramatic. He explained the way that rugby was racially segregated in South Africa and the violence he believed would be caused by the All Black tour. Essentially, he said if the All Blacks toured, then people in South Africa would demonstrate against it, and if they demonstrated, then they would be violently attacked by police.
It was to tell the story of the black people of the Republic of South Africa and our resolve to be free, which would be responded to by the lashing out of violence, which has already had a record of being lashed out on us. That's really the story I told. I reminded the court and the people of this country of previous occasions when these things had happened around rugby fields.
By the time the witnesses had finished giving evidence, it was already Wednesday. The plaintiffs and their lawyers were becoming concerned. It looked as if the trial would not finish before the All Blacks departed for South Africa 1 week later. If no decision was reached by then, the case may be a waste of time, as the tour would have already begun. Ted Thomas had indicated to the judge on the first day that he might seek what is called an interim injunction, an order from the court that the rugby union could not go ahead with the tour until the case had been resolved. but he waited until the third day of the hearing to make the application. The rugby union's lawyers believed this was a tactic to interrupt the tour preparations. Ted Thomas had a different explanation.
The reason for the delay wasn't that it wasn't the course to follow. Rather, it was that it required, because it was a civil proceeding, and it required a undertaking as to damages. And I wasn't prepared to put the resources of the two plaintiffs at issue. I knew that the lawyers could raise a lot of money, but as it turned out, not even the lawyers' contributions would necessarily cover damages if we failed.
Essentially, in order to apply for an interim injunction, the plaintiffs had to make an undertaking as to damages. They had to promise that if an interim injunction was granted, but they ultimately lost at the full trial, they would pay for any financial loss that the rugby union suffered as a result. Ted Thomas didn't want to put Paddy Finnegan and Phil Ricordan in that position. So, at short notice, he went around looking for someone who could guarantee the money. A number of lawyers had offered to support the plaintiffs, but it still wasn't quite enough. So instead, he sent a message to Jeremy Pope, a New Zealand diplomat based at the Commonwealth Secretariat. Ted Thomas received a response on the Tuesday night.
In those days, there was a telex that came through telephone. You didn't have texts or emails. And a telex came through. I was actually still working about 2 o'clock in the morning. Telex came through. Jeremy Pope, your damages are covered. There was no indication as to how they were covered, but I knew Jeremy well enough to know that it was backed.
Years later, Jeremy Pope would reveal that the undertaking actually came from the government of Sweden. The application for an interim injunction changed the whole case. Instead of proving their case in full, the plaintiffs had to satisfy a special legal test. First, they would have to show that they had what is known as a prima facie case, a case that, on the face of it, looks like it at least has a chance of succeeding. Secondly, the case has to be weighed against a possible hardship to the defendants, in this case, the rugby union and its councillors. Finally, once these issues are weighed, the judge has discretion to decide whether an injunction is appropriate in the circumstances. Douglas White, the lawyer for the rugby union, strongly opposed the interim injunction. He maintained that it was within the interests of rugby to promote high-level international sporting contacts, including with South Africa, and that the rugby union had carefully considered its decision and listened to a wide range of views. He noted the evidence of John Graham, the principal of Auckland Grammar School, who believed that the tour would not damage schoolboy rugby. The decision was reasonable, he said. Fundamentally, Douglas White argued the decision to tour was one for the rugby union alone. The Rugby Union Council was elected to look out for the interests of the people who were involved in rugby. So long as they acted honestly and in good faith, it was not appropriate for the court to interfere with a decision that had already been made by the union. The rugby union's lawyers found themselves in a difficult situation. The plaintiffs' lawyers had had 2 days to argue their case and had been able to call upon 4 witnesses to give evidence. The rugby union didn't have the opportunity to do any of this. Instead, they had no more than 1 day to make their case and could not call any witnesses. All their evidence had to be submitted in written form.
We were disadvantaged by not being able to have the full case heard. Until the application was made, we were in the start of a trial, not an interim injunction. And a lot of evidence would have been, this evidence was focused on the opposition to the interim injunction, filed under huge pressures of time, like in days, in order to tell the court what the impact of its decision to grant the interim injunction would be.
The rugby union's argument was that if the interim injunction were granted, the tour wouldn't just be postponed, it would have to be cancelled. This argument was supported by evidence from the All Black coach, Brian Lahore, who explained to the court the complicated process of planning a rugby tour, taking into account logistical factors such as coordinating schedules, stadium availability, and appropriate seasonal weather conditions. The New Zealand police also gave evidence that it would be extremely difficult to reconfigure the All Blacks' complex security arrangements. Essentially, both the All Black management and the New Zealand police were saying that if the interim injunction was granted, the entire tour would have to be cancelled, even if the rugby union ultimately won the case at the final trial. Cancelling the tour, or even changing its dates, would also impact hundreds of rugby fans who had already spent money on tour packages to travel to South Africa to watch the games. The stakes were high, and with the All Blacks due to leave the country on the following Wednesday, the time pressure was urgent. In an extremely unusual move, Justice Casey agreed to consider the case overnight on the Friday and deliver a verdict on Saturday, the 13th of July. The case was finally balanced. Both sides went to bed on the Friday night, uncertain of what the result would be the next day. The arguments presented at the hearing before Justice Casey raise an interesting question. Was it fair for the rugby union to have to answer to a court? At the hearing, Douglas White strongly argued that the council was elected to look out for the interests of its members, the provincial unions. Although some of them felt uncomfortable with the decision to tour South Africa, none of them had directly challenged the decision through the rugby union's own processes, such as its annual general meeting. So why should a court intervene? This question frequently arises in the context of public interest litigation. Courts have developed their own principles to decide whether an intervention is appropriate. For example, whether the case sits outside the expertise of a judge, or whether a particular organisation exercises powers similar to a government organisation. Standing, which we looked at in the last episode, is another tool the courts use to decide whether they should intervene. In this case, the rugby union forcefully argued that it was not appropriate for the issue to be decided by a court. Many of its leaders felt that they deserved the freedom to make their own decision without any outside interference. On the other hand, the plaintiffs felt that this issue was bigger than rugby and that it was in the public interest to ask the court to intervene. They argued that in a way, the rugby union was like a branch of government, and its decisions affected all New Zealanders. To an extent, you might remember that this argument was accepted in the Court of Appeal. Part of the reason it decided the plaintiffs had standing was because the issue was of such public interest. In the next episode of For the Good of the Game, we'll find out what Justice Casey thought about these issues, and ultimately, which side won the argument about the interim injunction. This podcast was made with funding from the New Zealand Law Foundation and support from the University of Auckland Faculty of Law. The audio of Arnold Stafile comes from the Stout Centre at Victoria University Wellington.